Bonjour tout le monde. Today, the Honourable Will Blair, Minister of Public Safety and Emergency Preparedness, and the Honourable David Lametti, Minister of Justice and Attorney General of Canada, will respond to a federal court decision. They will be joined by David Vigneault, Director of CSIS, and Nathalie Drouin, Justice Deputy Minister. Nous entendrons d'abord de brèves adresses de la part de nos participants qui seront suivies d'une période de questions et de réponses. Minister Blair, over to you.
Thank you very much, ladies and gentlemen, and good afternoon. I'd like to begin by thanking you all for joining us here today. I am, as you're aware, joined today by my colleagues, David Lametti, the Minister of Justice and the Attorney General of Canada, as well as Mr. David Vigneault, who is the Director of the Canadian Security Intelligence Service, and Ms. Nathalie Drouin, the Deputy Minister of Justice and the Deputy Attorney General of Canada. Earlier today, the federal court made public a decision in which it found that institutional failings by both CSIS and the Department of Justice led to a breach of CSIS's duty of candor to the court. Candor in this context refers to CSIS's duty to disclose all relevant facts to the court. In short, the court found that CSIS failed to proactively disclose all relevant facts used in support of warrant applications and that were derived from potentially illegal activities. As a result, the court has recommended a comprehensive external review in order to identify the shortcomings that led to these events. Public trust in government institutions is absolutely essential in the fulfillment of their missions. Protecting Canadians in a manner that is compliant with the law is something that I, as the minister responsible for CSIS, am absolutely determined to uphold. I want to be clear. I accept the court's decision and take its findings very seriously. Minister Lametti and I are committed to implementing the court's recommendations. The National Security and Intelligence Review Agency is, in my opinion, well suited to examine the issues that the court has brought to light. I have also written to the National Security and Intelligence Committee of Parliamentarians. We have requested that they look into the findings and provide recommendations on how to address the concerns raised by the court's decision, and then to report on their progress regularly to the National Security and Intelligence Committee of Parliamentarians. The government has retained Murray Siegel, a former Deputy Attorney General of Ontario, to provide advice on best practices in warrant matters. We have also retained John Sims, a former Deputy Minister of Justice and Deputy Attorney General of Canada, to provide advice regarding implementation of the Siegel report and more effectively managing and conducting warrant applications before the federal court. We have also commissioned Mr. Maurice Rosenberg, a former Deputy Minister of Justice and Deputy Attorney General of Canada, to conduct a review and to provide recommendations to improve the manner in which we meet our disclosure obligations to the federal court. And a final report was received from Mr. Rosenberg in March of 2020, and so the work to begin addressing the recommendations is well underway. I want to assure Canadians that CSIS works hard to protect our country and all Canadians from a wide range of national security threats. It is not an easy job we've given them. The court has acknowledged this and recognizes that the consequences of failure are significant. CSIS relies on the assistance of human sources, and at times this involves such measures as providing a cell phone or other electronic devices to a source. And I believe that in the case at hand, CSIS carried out its mandate in good faith and acted at all times in the public interest. The potentially illegal activities involved in this case are in fact common intelligence collection activities used around the world by national security and law enforcement agencies to investigate terrorism and to keep their citizens safe. At no time was the safety of Canadians placed at risk, nor, in my opinion, were our rights and freedoms threatened. The former Bill C-59, passed by the last Parliament, addressed these types of activities by providing CSIS with a limited justification framework to conduct activities that would otherwise constitute offenses. We recognize that accountability is fundamental to our system of government. It plays a critical role in building citizens' trust in their government. And to that end, a new ministerial direction for accountability was issued to the Director of CSIS to strengthen ministerial oversight over CSIS activities. And under that direction, Public Safety Canada works closely with CSIS to ensure that I am kept appropriately informed of all CSIS activities including those that pose a higher legal risk. This direction includes a section on CSIS's duty of candor to help ensure that the agency fulfills its duties to the federal court. Mr. Vigneault has assured me that CSIS is already implementing a number of concrete measures in order to address some of the issues relating to the duty of candor that were identified by the federal court decision. CSIS employees are dedicated to keeping Canada and Canadians safe and secure. Canadians can expect that all CSIS employees will at all times act with honesty and integrity, and in its activities respect the rule of law and the rights and freedoms guaranteed under the Charter. I'd now like to turn to Minister Lametti to say a few words. Thank you.
Thank you, Bill. Good afternoon. Bon après-midi. As Minister Blair explained, we are here today to speak about the federal court's decision. The decision highlighted serious institutional failings, both within the Department of Justice and CSIS, which led to a breach of CSIS's duty of candor to the court. This means that the court did not receive information it should have received in support of warrant applications. Je veux rassurer le public canadien. Nous prenons ce jugement de la Cour très au sérieux. Nous devons remédier à cet enjeu afin de s'assurer que nous respectons nos obligations envers la Cour et également envers tous les Canadiens et les Canadiennes. C'est particulièrement important pour les questions de sécurité nationale, qui sont extrêmement sensibles par nature et se déroulent habituellement dans les circonstances uniques afin de s'assurer la sécurité de la population canadienne. Comme l'expliquait le ministre Blair, nous avons déjà adopté plusieurs mesures importantes au cours des dernières années pour améliorer les structures internes, les communications et les mécanismes de contrôle qui sont à l'origine des graves manquements que la Cour a identifiés dans ce jugement. Since 2016, Justice Canada and CSIS have developed and implemented guidance and direction to allow both institutions to work more effectively together and clarify their obligations to the court with respect to the duty of candor. Some examples include the publication of the Siegel and the Sims review reports, the action plan, and the joint duty of candor policy. In addition, a comprehensive review and update of Justice Canada's legal assessment framework is already underway and will help improve the ways in which legal risk is assessed and how it is communicated to clients, that is, departments and agencies of the Government of Canada. This work is critical, but there is more that needs to be done. The court has told us that in the unique context of national security, Justice Canada has an even greater responsibility to not just identify legal risks, but to clearly communicate to government departments and agencies when an action could be contrary to law or otherwise problematic. The new verification structure contained in Old Bill C-59, an act respecting national security matters from the last Parliament, is an important tool to properly evaluate these situations once they are identified. But I have also made clear to the department that I expect this assessment to be clearly and directly provided to those at the highest levels of those departments and agencies. They have assured me that this will be the standard practice going forward. Comme le ministre Blair l'a mentionné, nous travaillons également avec l'Office de surveillance des activités en matière de sécurité nationale et de renseignement, l'OSSNR ou NCIRA en anglais, ainsi qu'avec le Comité des parlementaires sur la sécurité nationale et le renseignement, le CPSNR, NSCOP en anglais, afin de répondre à la décision de la Cour. Enfin, conformément à la recommandation de la Cour, je veux annoncer que le ministère de la Justice du Canada a engagé un conseiller externe, l'ancien juge de la Cour suprême, l'honorable Ian Benny, pour mener un examen complet des politiques et des pratiques du ministère de la Justice et du SCRS en matière de demande de mandat. Cet examen portera également sur la mise en œuvre des recommandations de l'OSSNR au sein de Justice Canada, ainsi que sur les meilleures pratiques dans notre rôle d'avocat du gouvernement du Canada. c'est-à-dire nos services de conseil à d'autres ministères ou organismes du gouvernement du Canada. En tant que décideurs et en tant que représentants de nos institutions, il nous incombe de nous assurer que les structures et les mécanismes de la démocratie canadienne fonctionnent correctement et efficacement afin de respecter nos obligations en vertu de la loi, mais aussi d'assurer la sécurité de la population. My Deputy Minister, Nathalie Drouin, who is here with us today, will help me lead these important efforts at Justice Canada and ensure that we can continue carrying out, with clarity and integrity, our responsibility to other departments and agencies, courts, and to the general public. I want to say a quick word about the appeal. We are appealing this decision on a narrow but important point of law, which, if allowed to stand, would create a precedent for future cases. But let me be crystal clear. We agree with the court's finding that serious institutional failures led to a breach in the government's obligation to the court. This appeal does not and should not take away from the important task at hand of remedying these failures and fully meeting our obligations to Canadians. And this is exactly what we are doing. Thank you. Merci. David?
Merci, messieurs les ministres, et bonjour à tous. Thank you, ministers, and good afternoon to all of you. I'm here today first and foremost to address the federal court's findings in this decision, one that I take very seriously. I would also like to outline the actions that we have taken and that we'll continue to undertake in order to address the court's concerns. CSIS operations are vital to our nation's security, and the court's role in authorizing warrants is a key element of our accountability framework. The court enables us to conduct our investigations, aligned with the rights and freedoms we all enjoy as Canadians. We fully respect the rule of law and the role the court plays, and we know that we must do everything we can to ensure that the court has all confidence in us. Comme vous le savez, la mission du Service canadien du renseignement de sécurité consiste à protéger le Canada et les Canadiens contre les menaces pour la sécurité nationale, comme le terrorisme, l'espionnage et l'ingérence étrangère. In doing so, we often rely on the assistance of human sources who have access to individuals or organizations that pose a threat to our country and who may put themselves at great risk to protect Canada and Canadians' interests. At times, we're required to pay these sources for information or to offer other logistical support, such as providing a cell phone to help them carry out their work. Let me be clear. The type of activities that are in questions in this decision are representative of routine bread and butter practices used by all intelligence agencies around the world. While it was never the intent that the anti-terror provisions in the criminal code would capture these routine activities carried out in furtherance of our mandate, they may nonetheless constitute offenses. For several years, CSIS relied on the legal doctrine of Crown immunity as a defense from criminal liability while engaging in these activities. However, as outlined in the decision by the court, CSIS' ability to rely on this defense and the legal advice relating to it evolved and changed over time. In January 2019, CSIS and Justice Canada determined that we could no longer rely on Crown immunity as a defense. As a result, I immediately directed that these activities be suspended until BLC 59 be passed, and I informed the court and our national security review bodies. Ce n'est pas une décision que j'ai prise à la légère. Les employés du SCRS ont toujours agi de bonne foi, en ayant toujours clairement à l'esprit leur mission de protéger les Canadiens. Pour éviter que la sécurité publique soit exposée à des risques pendant cette période de suspension, les employés du SCRS ont fait preuve de résilience et d'innovation. Je suis très fier des efforts qu'ils ont déployés. As mentioned by Minister Blair, we worked very hard with colleagues at Public Safety and the Department of Justice to draft a legislative solution. The National Security Act of 2017 has addressed this issue by providing CSIS with the ability to conduct these activities within a clear legal framework modeled on that already in place for law enforcement. But beyond that solution in law, we have taken a significant number of concrete actions to address the court's concerns over the candor issue in this matter. All of these are underway, though there are significant efforts that will take time. In response to the court's concern, I commissioned a review of CSIS candor obligations. We are currently in the process of implementing transformative change in line with the recommendations of this review and are ensuring that it's properly resourced with a dedicated project team. We have created a dedicated unit specifically charged with ensuring that our disclosure obligations to the federal court and are well understood and met during the course of national security investigations. We have delivered extensive training and are continuing to ensure that all designated employees have a full understanding of their obligation under the justification framework provided by the National Security Act of 2017. De plus, conformément aux récentes instructions du ministre en matière de collecte et de reddition de comptes, nous avons élaboré une coopération avec Sécurité publique, un cadre de coopération dont l'objectif fondamental est d'assurer la transparence et la reddition de comptes. We will continue to work with Public Safety, the Department of Justice, the National Security and Intelligence Review Agency, the National Security and Intelligence Committee of Parliamentarians, and the Intelligence Commissioner, and welcome their continued insight to ensure that the concerns raised by the federal court are addressed. CSIS must operate in a very complex geopolitical landscape where sophisticated technology is widely available to actors hostile to Canada and our way of life. It is important that we ensure that we have the tools and authorities required of a modern intelligence agency. This work is never finished. Keeping pace with changes in the legal, technological, and threat environment will ensure that we continue to fulfill our mandate of keeping Canada and Canadians safe, and do so in a way that is consistent with Canada's values and the trust that Canadians place in us. In closing, I would like to reiterate that all CSIS employees have a very important responsibility. They are dedicated professionals and work tirelessly to keep us safe. I want to take a moment to thank them all. Merci.
Thank you, Ministers. Merci beaucoup, Monsieur le Directeur. C'est une décision importante de la Cour que le ministère de la Justice et moi-même prenons aussi très au sérieux. And there were a number of factors within justice that resulted in this outcome. In order to perform its important role, the federal court must be able to count on justice and CSIS to bring before it the facts it needs to decide whether to issue a warrant to authorize investigation into threats to Canada's security. Here, the federal court did not get all the facts it needs in this particular case. We must and will do better. For several years, CSIS relied on Crown immunity as a defense for potential illegal activities. During this time, justice advice evolved in this area, indicating to CSIS the vulnerability of this defense. Justice recommended that new legislation was needed. Bill C-59, the National Security Act, which was introduced in June 2017 and became law in June 2019, addresses this issue. However, it was in January 19 that Justice Canada and CSIS determined that CSIS could no longer rely on this defense. And as such, as the director just said, CSIS immediately suspended all such activity. La Cour dit que nos avis doivent être plus clairs. La décision indique également que la façon dont nous gérons les risques juridiques ne convient pas à la pratique des activités du Service canadien du renseignement de sécurité. Nous sommes d'accord et avons déjà commencé un examen exhaustif et une mise à jour de notre cadre de gestion des risques juridiques afin d'améliorer la façon dont les risques sont évalués et communiqués. La Cour dit d'autre part que notre avis n'a pas été donné en temps opportun. La Cour souligne également que les avocats plaideurs et les avocats conseils n'ont pas partagé l'information et les avis au moment où ils auraient dû le faire. While it is understandable that when dealing with top-secret information that is only shared on a need-to-know basis, information practices can be challenging. But we agree that this can never be a justification for not ensuring that the court has all the facts before it when considering a warrant application. We continue addressing these silos and are improving our information sharing practices. The court has raised duty of candor concerns before. While we have been working with CSIS to implement earlier recommendations to address these concerns, we need to and can do better together to make all the changes needed. And of course, I look forward to the recommendation that the NSRA review will provide. I also welcome the advice that the external advisor will give to my department and the minister on the implementation of this recommendation. The rule of law and duty of candor, the responsibility to be truthful before the court, are foundations of the legal profession. These foundations are at the core of the legal advice we provide to government departments and agencies. I know that the culture at Justice is to act with honesty, integrity, professionalism, and I know also that all employees understand and respect the rule of law, and I'm proud of the work they do. J'espère que cette décision et l'examen à venir nous donneront l'occasion de mieux comprendre nos rôles, d'améliorer la façon dont nous donnons des conseils juridiques, en particulier aux clients qui ont des mandats de sécurité nationale, de favoriser une meilleure relation de travail, une relation de travail plus solide avec nos ministères clients et surtout, de nous assurer que nous jouissons de la confiance du public dans ce travail. J'espère que cette décision et les examens et les conseils externes à venir nous amèneront à faire encore mieux. Je suis convaincue que le ministère de la Justice est à la hauteur de la tâche. Merci.
We will now open the floor for questions. As a reminder, please limit yourself to one question and one follow-up. Please begin your question by identifying yourself, naming the media outlet you represent, as well as who your question is being addressed to. We'll begin with questions over the phone. Operator, please proceed with our first question.
Thank you. Merci. Please press star 1 at this time if you have a question. Veuillez appuyer sur étoile 1 maintenant pour poser une question. The first question, la première question est de Jim Bronskill from the Canadian Press. Please go ahead, la parole est à vous.
Hello. The ruling is quite clear. Reliance was placed on Crown immunity despite the service having been advised by senior counsel in the context of a revision to the ministerial direction that bestowing Crown immunity on CSIS is not consistent with the CSIS Act. The ruling goes on to say, nonetheless, the service continued to rely on Crown immunity, doing so in the face of unambiguous direction from the minister that the service must observe the rule of law. Will anyone lose their job or be disciplined over this breach?
Well, Jim, if I may, this is Bill Blair, and I'd like to answer that question. First of all, as we've indicated, this was an evolving and complex area of law, and in my experience and in my review of all of the circumstances leading up to this decision, I believe that at all times people were acting in good faith in an effort to fulfill their responsibilities to uphold the rule of law. We also acknowledge and are grateful for the finding of the court that but I think it's important to articulate the work that was done in response and when the service became aware that the actions may be in violation of that rule of law, they immediately halted operations. That was in January of 2019. The government had already taken significant actions with the implementation of the National Security Act introduced in 2017. And in September of 2019, my predecessor, Minister Goodall, issued an order to strengthen the ministerial oversight of CSIS activities, which included requirements of them to inform the ministry of their activities, including those which posed a high risk, and enhancing reporting requirements to ensure that CSIS's duty of candor to the federal court is fulfilled. I also would want to acknowledge that the director of CSIS and all of his staff have been working very diligently to begin implementing a number of very concrete measures that are being put in place to address the duty of candor responsibilities that the federal court decision underscores. A number of very significant steps to be taken, and I believe that responsibility for the actions identified by the court as deficient is to fix that which was unacceptable to the court. I have been very confident in the work that has been undertaken, both by officials at CSIS, but also at Justice Canada, who have very much acknowledged and respected the decisions and the direction of the court. And they've made a very sincere effort, in my opinion, to seek legal advice and recommendations to assist them in that implementation. And they have submitted quite fulsomely to the oversight of NCIRA, NCCOPS, and the Public Safety Minister and the Minister of Justice as required under the Act. And so, we acknowledge that there needs to be improvement, but let us also acknowledge that an enormous amount of work has gone into this, and I think what underlines that, and I think Canadians can be reassured at all times, CSIS and Justice Canada acted in good faith and continue to work diligently to address the court's concerns. We now have greater clarity from the courts as exactly what is required, and we are absolutely committed to addressing those deficiencies and making the improvements that are required.
Mr. Bronskill, I can add that I received a report from Minister Blair's predecessor, Minister Goodale, under Section 20 of the Act, which I considered and which I also received external advice upon from Justice Eleanor Cronk, who is a retired Justice of the Ontario Court of Appeal. And based on all of this information, and the legal advice that I obtained and my analysis, I determined that it is not in the public interest that matters be identified, that any individuals from CSIS be referred for prosecution.
Thank you, Ministers. Jim, follow up?
In one case, CSIS paid an individual known to be facilitating or carrying out terrorism an amount totaling up to $25,000 over a few years. This was illegal under the criminal code. How does CSIS justify giving tens of thousands of dollars to a terrorist?
Well, Jim, on operational matters, I'll defer to the director, but let's be clear. I think the director's made it very clear, and the courts have also acknowledged that the steps that were taken, although clearly have been determined by the courts to have been unlawful and not according to the rule of law. But at the same time, they have been those types of payments for expenses that a source may undertake, or the use of a cell phone, or even paying for a meal. Those things under law now and under the regime that we've put in place with this National Security Act must be reported to the courts. But at all times, these are normal practices in the conduct of the investigations, all intended to ensure that the safety and security of Canadians are being maintained. And I have confidence in that work. It is subject to considerable oversight and scrutiny. I think clearly there needs to be greater candor. The courts have identified that these issues must be disclosed to them. I think we've taken some very significant steps through the National Security Act to put in a legal justification framework so that these matters may be more appropriately identified to the court. But I believe that it is not inconsistent with the normal course of the duties that have been performed quite ably by our security services and the national security establishment over many, many years.
I can add one thing to this question. Each and every operation of CSIS requires a review of different types of risk. And this specific case, I will not go into the details. The details of this are classified, but I can tell you that we have, and my predecessors in this case have reviewed the details of this operation, the risk that the different individuals involved represented to the safety and security of Canadians, and I've made the decision again based on the procedure and protocol that existed at the time to carry out this operation, always under the notion that the Crown immunity was applicable in this instance.
Thank you. Operator, next question.
Thank you. As a reminder, please press star 1 for any question. De nouveau, n'hésitez pas à appuyer sur étoile 1 pour poser une question. And the next question, la prochaine question, est de Colin Fries from the Globe and Mail. Please go ahead.
Director Vigneault, the court ruling called you a director for approving 10 potentially illegal activities at a time when you knew or should have known that those were illegal activities. It also questions whether you have moral authority, given that you put your own intelligence officers at risk of potential prosecution for doing things that you knew or should have known to be illegal. So I'm wondering how you would react to these characterizations in the judicial ruling. And, it's one of your predecessors resigned in the 80s for getting making errors in admission in one wiretap application. This affects several. So given that you've been found in a judicial ruling to have approved somewhere between 11 and 99 potentially illegal activities and to expose your own intelligence officers to risk of prosecution, do you expect to continue to lead the service?
So I'll take the question, Minister. I've been quite clear in my statement that the activities that we have undertaken have been in the guise of protecting Canadians from the threats of terrorism. In this specific case, we have said that we have carried out these activities with the protection of the Crown immunity. When it became clear in January 2019 that the Crown immunity was not available protection anymore for these activities, I immediately ordered that we cease these activities and we carried out our counterterrorism operations in a different way. And I want to applaud the work of the men and women of CSIS, the people of CSIS who have been able to find innovative ways of being able to collect the crucial intelligence that is at play here. Minister Lametti has also addressed the question of the report, Section 20 report. I referred to these matters to Minister Goodale at the time, and I myself and my senior executive, my head of operations, and my predecessor, the previous director of CSIS, we took accountability for the actions of all employees. We didn't shy away from that accountability, and we provided that Section 20 report to Minister Goodale at the time.
Follow up?
Well, I'm wondering why January 2019, because this really makes it clear there was a lot of paper flying around justice to the minister, to the previous director, to the current director, to various ministries your violate law to make these payments to provide these cell phones, these $25,000. You also had live legislation before the court where this government told Parliament that the CSIS operatives, intelligence operatives, and operators were exposed if they didn't have this law. And that's why Parliament passed this law. So given that, I'm wondering how we can all say that clarity came only in January 2019 when the judge's ruling suggests that you should have known well before that the activities in question were contentious or likely illegal.
As I've said clearly in my statement, that the legal advice was clarified, and we came to a conclusion with the Department of Justice in 2019 that we could not rely on Crown immunity. And that's why they immediately asked that these operations ceased, and we find other ways to find a way to protect Canadians by collecting the intelligence in other ways. So at that point, the Parliament was already considering C-59, but there was a period of a number of months where we could not undertake these operations.
And Colin, if I may also just briefly follow up, it had been clearly identified that these operations did constitute a high legal risk. And that was acknowledged in the introduction of Bill C-59, that we were looking at ways in which these risks could be better managed through a legal justification regime put in place through that National Security Act. And so it was when the Justice Canada and CSIS came back to the minister of the day and said that these actions were likely unlawful. They made the decision to immediately halt those operations, and until the legislation passed and was put in place to establish that justification. And so from the outset, I think there was an acknowledgement from the service and from justice of the legal risk. There was a very sincere effort to manage that risk through legislation. And when the service and Justice Canada determined that risk crossed the threshold and was likely unlawful, they took immediate actions to terminate that risk and to cease those operations until the new legislation could be put in place. As I've indicated, this is an area of complex law, and the concerns were being identified and responded to, I believe, in a thoughtful way. And with the decision in this matter today, we have greater clarity, and we have already begun to take very significant steps to ensure that we uphold our duty of candor at CSIS, and that we continue to uphold the rule of law.
Thank you, Minister. We'll now go to the room. Mackenzie.
Hi, Mackenzie Gray with CTV News. My first question is for the CSIS director. Your previous predecessors, Dick Fadden and Ward Elcock, have been quite outspoken in saying that Canada should not allow Huawei into the 5G network. What is CSIS' position, and what's your position on this issue? I asked you, sir.
Minister?
Yeah, I thought your question was directed to the director, but let me be very clear. Our national security establishment, which includes CSIS and CSE, has done an excellent job of making sure the government is well informed of the risks that various entities might pose in a 5G environment, and so those security concerns have been well articulated. In addition, they are also part of a very significant conversation that goes on between ourselves and our Five Eyes partners. I've been involved just quite recently in extensive conversations with our Five Eyes partners with respect to this. I believe that those security concerns have been very well articulated and are clearly understood by our government. We also recognize that there are a number of other considerations, both technical and geopolitical, which are also considered in the larger context. But let me be very clear. At all times, we will act in the interest of Canadians, and we will never put Canadian security or safety at risk. We have an obligation to ensure that the technical environment that Canadians work within and enjoy in this country will always be safe. And so I'm very grateful for the excellent work done by our security services, both at CSIS and CSE, in ensuring that our decisions are well informed by their expertise and their advice, and the comprehensive knowledge that they provide us with the threat environment that exists there. And I would acknowledge that it is a significant threat environment it informs the decision that we will make. We're working very hard to make sure that we do what is right for Canadians, and I want to assure Canadians that's a decision that will be made by Canada for Canadians, and not on anyone else's schedule but ours. But we will always act in the best interest of Canadians, and we will never compromise their safety and security. We are very well served by our national security establishment in ensuring that all of our decisions are well informed by their work.
Out of respect to your question that was posed directly to me, I would first say that I welcome enlightened opinion by my distinguished predecessors. I think it's very healthy in a democracy to have these debates about national security. I think the country and democracy is better off having these views. I have very specific views about this matter. We have been reviewing the question for some time. We continue to work with partners, and as you can understand, I will be providing that advice to the government. Thank you.
Follow up?
Yeah, my follow-up question is about the hack today from Russia allegedly going after vaccine companies to get information about that. Mr. Blair, what's your reaction to that, and how concerned are you about foreign powers, Russia, China, any other countries potentially getting sensitive Canadian information about COVID-19. And to the CSIS director, can you tell us specifically what has CSIS done to make sure that Canadian companies, universities, other organizations that are working on COVID-19 are protected? And have there been any other instances that we've seen so far of foreign powers or malicious actors attempting to get that kind of information?
Yeah, if I may, let me begin, Mackenzie. Canada takes very seriously the security of our industries. The pandemic and the global search for an effective vaccine is something that Canada is very much an important part of. But we recognize that there are foreign actors, threat actors, who would attempt to hack into that information and to exploit any vulnerabilities. And we remain absolutely vigilant. And I will tell you that that is the subject of continuous and ongoing, very intense scrutiny to protect Canadian interests. I'm naturally disappointed, but at the same time not surprised that there are foreign entities that would attempt to exploit these matters. And I'm very grateful for the work, particularly that CSE does in protecting Canadian industry and Canadian interests, in the protection of intellectual property, and most particularly protecting Canadian interests in the development of that vaccine. We will remain vigilant, and there's a good, very close collaboration that needs to be acknowledged as well between our national security establishment and Canadian industry and Canadian research scientists right across the country to ensure that we support and enable those researchers and those industries to operate with security and to protect their interests, because their interests very closely align with Canada's interests. And so we'll do what is necessary to protect Canadian interests. David, I don't know whether you wanted to comment further.
Thank you, Minister. I will just add that, as you mentioned, this is a global issue. Every actor in the world is looking for the vaccine. And in this context, in Canada, we have very sophisticated, cutting-edge organizations that are engaged. CSIS has been involved and engaged for months now in doing our intelligence activities. So we do work covertly to advise the government of different threats related to this issue. But we also, as having this insight, we are engaging very openly with companies. Just today, we were doing a webinar with the Canadian Chamber of Commerce. We have an outreach program that has already reached over 150 companies across Canada in the biopharma sector to provide them with information about the threat they face and also about potential measures they can take to protect their intellectual property in this heightened threat environment.
Thank you very much. And our last question is going to be from the floor.
Olivia Stefanovic, CBC News. Thank you for your time this afternoon. For the director of CSIS, do you believe Canada's laws are too restrictive to allow your agency to effectively do its job in today's world? And if so, what would you like to see changed? And I'm wondering if the ministers can weigh in afterwards.
Minister Blair, do you want to go first?
Yeah, I think it's very important to acknowledge that accountability is fundamental to our system of government. It plays a critical role in maintaining Canadians' trust not only in their government, but in those agencies, departments, and Canadians who are responsible for keeping us safe. We expect CSIS to deliver on their mandate at all times in accordance with the rule of law and respect for the rights and freedoms that are guaranteed under the Canadian Charter of Rights and Freedoms. There's no higher law in this country than that Charter of Rights and Freedoms, and it guides all of our agencies' work, and it has to. As well, I'm confident that CSIS understands the importance of accountability and is fulsome in their reporting, not only to me, but working with the oversight agencies that we have put in place, both NCIRA and NCI COPS. There is that clear acknowledgement, and we benefit tremendously, I think, from the very sincere advice that we receive in the collaboration. And I think Canadians can draw some confidence in the very close collaboration that exists between our justice officials and our national security establishment. We are absolutely committed to maintaining that accountability to Canadians in upholding at all times the rule of law. And as the law evolves, as it has in this matter discussed today, then we need to be responsive and respectful of that law and take the steps as quickly as possible to ensure that we are at all times in compliance. And for that, we are grateful for the advice and the direction that we have received from the courts in this matter. And I think it helps us fulfill our obligation to ensure Canadians that we will at all times work to keep them safe, and we will at all times work to work within the rule of law. Compromising the rule of law fundamentally has the effect of compromising the security of Canadians and our government. And so adhering at all times to that rule of law is the only way to do business. And I'm confident of the commitment of the national security establishment, CSIS, CSE, and their important advisors and partners in Justice Canada to ensure that we at all times uphold that law in this country so that Canadians can have confidence that people working hard to keep them safe will also work hard to uphold the laws and the values of Canada.
I would just add from my part that there's a complex balance that Minister Blair is referring to between the security agencies, so CSIS and the CSE, the Justice Department and its lawyers, and the federal court. And through the interactions of those actors, I think we achieve an appropriate balance of protecting the rule of law, providing effective safety and security to Canadians, and at all times respecting the Charter.
CSIS is an intelligence organization, but we operate in a democratic country. That's not the case for all of the other adversaries that operate in intelligence. We, as ministers have said, the rule of law is absolutely fundamental to what we do. I mentioned in my statement that the world is getting more complex. The threat environment is changing. The complexity of the technological environment and the geopolitical landscape is evolving. And in this matter, in this context, I would say that, it is incumbent upon all of us to understand what are the effectiveness of the intelligence services and make sure that the proper legal framework continues to evolve with these matter. This is why we have such a robust, discussions between the departments, between the Department of Public Safety and, other players engaged. So I don't believe that the work will ever be finished. We need to continue to look at it because this is what Canadians will expect of us. They want us to be effective, but they want us to be effective in a democratic way, respecting the rule of law.
Thank you. Follow up.
And for Minister Blair, on the story of the hack, has this set back Canada's vaccine research? And are you concerned about possible other attacks by Russia specifically?
Thank you for the question. I do not believe that it sets back our efforts, but it's a useful reminder to all of those scientists and industries right across Canada who are working very diligently to find that vaccine. Canadians and the world needs it. It's important work. We remain concerned, and not just the Russians targeting it, but other foreign actors as well. There are unfortunately people in this world who don't play by the rules and represent a risk, even a threat to Canadian interests and to everyone's interest. And so we will always work to protect Canadians' interests. We'll work to I think Canadians have a great deal to contribute globally to helping find that vaccine. We've got some outstanding people in this country working on it. We just want to make sure that they can do it safely. And I want to reassure them and Canadians that our national security establishment is well engaged in that effort to protect them and protect our interests so that they can do the work that we all need them to do.
That's all the time we have today. So thank you very much for joining us.